formulation doesn't answer the question of where the press obtains the information illegally, unlawfully. The court in Pentagon Papers, remember, knew that somebody had acted unlawfully, but didn't know that it was the Times. Would the case have gone differently had the Times burglarized the Pentagon and gotten a copy of the Pentagon Papers? Might have. But they didn't know that it wasn't true, that the Times had clean hands. They delivered the Pentagon Papers. Well, the court in the Florida style leaves open the question of whether the press would have constitutional protection if it had acquired the information illegally. Still an open question. But the court, Justice Marshall concludes in the Florida Star case that this principle, Smith versus Daily Mail, that precedent, clearly commands reversal. Look, they got truthful information, BJF name. And what happened to her happened to be truthful. Nobody questioned that. There was nothing false about it. How did they get it? They got it lawfully. They sent their intern down to the press room at the police department, which is open to anybody to walk into, and read it on the police bulletin board, and wrote it down. They acquired the information lawfully. They didn't burglarize or bribe, act illegally in any way in acquiring the information. And the information is about a matter of public concern, the commission of a serious crime, a rape, in the community. That's the kind of information that the citizenry is entitled to know about. So those three predicates of the Smith versus Daily Mail rule, truthful, lawfully acquired, about a matter of public concern, are all met. Then the question is liability, punishment of the press, needed to serve a state interest of the highest order? And that's the bulk of the court's decision. Justice Marshall concludes, for three independent reasons, imposing liability for publication in this case is too precipitous a means of advancing the state's interests. Marshall does not poo-poo the state's interests. The state advanced three related interests as saying that they justify imposing liability here. One is protecting the privacy of victims of sexual offenses, against having it bruited about in the community that they have been sexually assaulted. Protecting the privacy of victims is one valid state interest. Protecting the physical safety when the perpetrator is still at large. They hadn't caught the rapist, and he had threatened to rape her again. And protecting her physical safety is a valid state interest. And finally, the state advanced the goal of encouraging victims of sexual offenses to come forward and report and agree to help the prosecution in sexual offense cases was an important state interest. So Marshall didn't say those are insufficient state interests. Those are important state interests. But, he concludes, for three reasons, there's not a good fit between serving those interests and liability in this case. It's a narrow tailoring idea. The court is, in effect, exercising strict scrutiny here, acknowledging that the interest may be compelling, doesn't use that term, doesn't use the term strict scrutiny. Important state interest, but is imposing liability on the press or disclosing the name of the victim of sex offense, is that narrowly tailored to serve the interest, or is it over-inclusive or under-inclusive? The kind of analysis that by now is very familiar to you. So he looks at these three reasons. One is, look, the government itself provided this information. If the government is so concerned about protecting the privacy of victims of sex offenses, why is it giving out the information to the public? It could simply keep it in-house, not put up the information on the press bulletin board. The government has failed to police itself, Marshall says, and that can hardly be said to be a narrowly tailored means of safeguarding anonymity. And then the second reason why the penalty is not needed to serve the state's purpose is that liability under this Florida law followed automatically from publication. There's no fault requirement, as in New York Times versus Sullivan. That is, if you published the identity of a victim of a sex offense, you're liable, even if the identity of the victim was well known in the community, even if, he points out, the victim has voluntarily called attention, public attention, to the offense, and without any blameworthiness requirement, scienter, that's what calls it, it's blameworthy state of mind, without any fault is involved here. It would be perverse, Marshall says, to impose liability without fault here on the publication of truthful information about a matter of public concern when the least protected falsehood received constitutional protection under the Sullivan doctrine. The least protected falsehood, meaning the one about a private figure. Even a private figure in a libel case has to prove that the false statement was made with some degree of fault, at least negligent, Whereas under the Florida law, even if the victim is known or goes public with it, and regardless of the fault of the publisher, there's liability. That's overbroad, that's over-inclusive, and not a good fit, not narrow tailoring. And then the final reason, the third reason, is that the law itself prohibits publication of the name of the rape victim only by an instrument of mass communication. And that's under-inclusive, Marshall points out. It's facially under-inclusive because it does not prohibit the spread by other means of the identities of victims of sexual offenses. An individual, not an instrument of mass communication, an individual who spreads the gossip over the backyard fences and so on, may in fact cause greater injury to the victim than the publication of her name in the back pages of a newspaper that nobody knows who she is, because the name doesn't mean anything to her. Being labeled by gossips in the workplace, in the neighborhood, may be more hurtful to the victim than publication by an instrument of mass communication. And if the state is really trying to protect the privacy interests of the victim, you don't have to do it across the board, even-handedly, by anybody who discloses the information, not single out an instrument of mass communication. So the court concludes that the statute is insufficiently tailored to protect the interest in anonymity, where it's only directed at newspapers or presumably radio and television stations as well. So we hold, signal that the court is about to tell you what the ruling is, we hold, not that privacy has no protection, not that the press always wins when it's true. We hold only that where a newspaper publishes truthful information which it has lawfully obtained, punishment may be lawfully imposed, if at all, only when narrowly tailored to the state interest of the highest order. Scalia concurs in the result, saying that third reason, that bad fit, that singling out the instrument of mass communication, is enough to condemn this law because the law leaves appreciable damage to the supposedly vital interest unprohibited. Justice White dissents, saying what you've done is basically eliminate the protection that individuals have for invasion of privacy against press. That's grossly overstated. The court does no such thing. But is Florida Star a case in which the press clause governs? I don't think so. It does certainly never says so. It does not rely on the press clause as the basis for decision. It is an important protection for the press, but it does not single out the press for any special protection. And presumably, if any blogger, non-press person, anybody posts something online, as these days happens about rape, a law could be applied to everybody, but it couldn't single out the press for special discrimination. People? Whether they can publish all information about them, just like where they live. Well, another way of, I think where your question goes is how could you repair this law so that it would be constitutional? Well, you could attempt to repair the defect. Government would not give away the information. Liability would attach only if the victim had not gone public herself, the offense wasn't already known in the community, and only if there were fault by the publisher, that is negligence or malice or something like that. And on the last, it would apply across the board to everybody, not singling out the press for discriminatory treatment. So you could repair the law. I don't think Florida did, and it may not serve the same purposes. Yeah. Poor form. Right. It's an editorial choice, and most publications say that it's our policy not to publish the names of victims. And some of them have policies against not publishing the identity of minor victims of crime, especially sexual crime. And there are some laws, like Washington State, I know, passed a law forbidding the press from publishing the name of minor sex victims. I don't know how that would fare under the Florida Star analysis. Would it? It's not your speech. It's not your speech. You as a victim are trying to stop a newspaper or somebody wants to publish information of public concern that they lawfully acquire. The compelled speech doctrine from Jehovah's Witnesses wouldn't apply in that kind of situation. Somebody else would. Okay. Yes? No? Okay, there's another case that we need to discuss. I can't do it today, but we'll do it on Thursday. And then I want to talk about the issues in the paper and see how we came out on that. So I'll see you Thursday.